as we see an increased focus on Indigenous rights and jurisdiction, there will be more intersection with these issues of resource development and major projects. I think it's important to recognize that this is exciting. It's actually an opportunity for better relationship building and more durable forms of economic reconciliation because rights are clear, governance capacity of Indigenous governments is increased, and so the opportunity to partner in these projects is greater than it has been in the past.
Welcome to Colliers Talks, a podcast series featuring the latest trends, insights, research, and developments in commercial real estate in Canada and beyond.
Okay, welcome to the Colliers Talks podcast. This is one I have wanted to do for a while. We need to address this topic. You see it everywhere. It's all over the news, especially in the real estate industry. And I think we're all flying blind a little bit, is my opinion. So hopefully we are going to correct that today. We're going to get some real, actual insight into the Cowichan decision. So I am joined by Adam Wheeler. Adam's a partner at Fogler Rubinoff down the road from us in the litigation and dispute resolution department. So he's represented clients in criminal, civil, constitutional, and Indigenous and Aboriginal law matters. So he's appeared at all the levels of the courts. He's been in the Supreme Court, and he focuses on appeals, judicial review, treaty litigation, land claims, all of our favorite topics for this podcast. So Adam supports Indigenous governments in the regulatory areas, including resource and energy development, hot topic, child and family well-being, and criminal justice. So Adam, thank you for coming on the show. I'm really looking forward to this.
Thanks for having me, Adam.
Okay, this is going to be good. We're going to get right into it. So the Cowichan decision has just sort of blown up in the real estate world, but I think in the this is sort of coming out of left field for us. I think in the legal world, this is, I don't want to say it's old news, but when we talked earlier, you said this is something that has been developing for years, maybe even decades. So the Lower Mainland, the Cowichan land rights, can you, first of all, before we get into it, can you describe the case briefly for people who aren't familiar, who are just popping in on this podcast?
Sure. I'll try to do it justice, but I think it's 800 paragraphs. So let's try to go a little bit shorter than that. So Cowichan tribes brought an Aboriginal title claim involving their traditional village of Indigenous, which is now modern-day Richmond, British Columbia. So we'll talk more, I think, about what an Aboriginal title case is. But in essence, they went to court to prove their historic, exclusive use and occupation of that area prior to the assertion of Crown sovereignty. Based on that, they sought certain legal declarations, so a declaration of Aboriginal title and related rights in that area. So the case involved both the federal and provincial governments. You'll hear me talk about the Crown. That's what I'm talking about as we move forward. The City of Richmond, the Port Authority, and two neighboring nations who also claimed overlapping traditional territory. Importantly, and I think we'll talk about this a fair bit, no private landowners were defendants to the claim. So first, a declaration is very different than, say, the court making an order to transfer lands. It's a legal ruling that's intended to clarify the rights of the parties. So it doesn't necessarily require orders for remedies for breaches of those rights. Cowichan tribes in this case were asking the court to recognize rights grounded in their historic occupation, use, and governance of that land before the Crown asserted sovereignty. This was a very long case, and that's why I said it was 800 paragraphs or so. I think it's far more than that, many paragraphs. It was 500 days of trial. And part of the reason cases like Cowichan are so lengthy and evidence-heavy is because when you consider what they're trying to prove in court, historical occupation and land use, that requires oral history evidence. It requires archaeological evidence. It requires expert evidence, documents, maps, going back hundreds of years. So this is a big case, big claim, lots of evidence. After all of that, the British Columbia Supreme Court found that Cowichan tribes had proven Aboriginal title over part of the area they were claiming, as well as an Aboriginal right to fish. And there's a difference between Aboriginal title and Aboriginal rights that we might get into, but a right to fish on the south arm of the Fraser River as well. The part that I think is most interesting for the listeners will be the court then moved on to consider what were the effects of that finding, what legal results were there, and what did that mean for historic Crown land grants of fee simple title and other Crown actions that were made, even though there was a finding of Aboriginal title, that Aboriginal title existed. So just to explain that a little bit more, historically, in the early days of colonization, the Crown asserted sovereignty and began granting land in fee simple to settlers. And fee simple, your listeners will know about it, it's the form of private ownership that most Canadians associate with owning land, right? So that's rights to occupy, to use, to exclude. But the legal problem that the court had to grapple with in Cowichan was that having found that Cowichan established Aboriginal title, that Cowichan had proven exclusive occupancy and use of the lands prior to Crown sovereignty, what did that mean for the Crown's ability to grant fee simple interests to settlers in that land? Based on that, the court in Cowichan found that Canada and Richmond's fee simple titles and interests were invalid. They found that the Crown didn't have the legal authority to give away those rights in the first place because they instead were vested in the ancestors of the Cowichan tribes. There's lots there to unpack, but I think one piece I want to underscore right from the beginning is that this outcome did not mean and does not mean that private homeowners suddenly lose their property. This case is really about reconciliation of Aboriginal title and the existing fee simple interests in the area. So now, what follows from that decision, appeals notwithstanding, is a period of negotiations. So the court has directed the Government of Canada and the province to negotiate how those interests granted to third parties would be reconciled with Cowichan's Aboriginal title. So that's it in a nutshell, but I'm happy to drill down to anything more specific.
Okay, much appreciated. And I think it's very helpful because I can say honestly for myself, and I think most people who work in real estate, a year ago, 2 years ago, I didn't know anything about this. The perception is that this is a lightning bolt that came out of the sky, or the government decided to do this. But I guess, like, if we're looking at how did we get to this point, this was brewing for years, decades. There were smaller versions of this. Like, it's a very high profile case and it's sucking up a lot of oxygen. But is it fair to say that, like, this has little to do with the current federal government, the current provincial government, the mayor, whatever? Like, this has been a wheel that's been spinning for a long time, right? To get to this point. Is that fair?
Oh, absolutely. I mean, if you think about just even the time required to gather all of that historical evidence, that oral evidence, this takes decades. And I don't know how fast you think the courts are moving, but 500 days of trial takes many years to work its way through the courts. So, this is something that predated several BC governments have been in power during the course of this decision. And I think it's important to also recognize that because there's so many complex legal issues that are somewhat unprecedented or new and novel, there's always appeals, there's always components of these cases that stretch out even longer. So litigation's expensive and complex, but in this case, it was the path that Cowichan tribes chose, and we now see the result of that. But it's been a long time brewing.
And what's next? I guess, like, I think the feeling is, oh my God, this is a seismic decision. This changes everything. But I think there's questions by the listeners, by me. Is this going up to a higher level of court? There's going to be appeals, or is this just a matter, like you said, of maybe this sets the stage for a settlement, for a negotiation, for resolving this? But I think there's maybe some misinformation out there, or just fear about it. So what happens in the next year, say?
Yeah, it's a great question. I'm happy to try to clear that up. So when it comes to some of the questions that were not resolved, one of the unique aspects of a lot of Indigenous rights litigation, and we're using the word Aboriginal title in this case just because it's the language that's used in the Constitution, but we're talking about Indigenous rights generally, is that the courts really direct litigants and the Crown, it often involves Indigenous governments and the Crown, to resolve things on a nation-to-nation basis out of court. There's multiple reasons for that, but it's something that the court often directs the parties to do. And declarations like Aboriginal title declarations can be valuable because it allows the court to say, okay, all of the issues that you need to negotiate, we're going to give you a decision on this one so that you can negotiate how to implement that or how these pieces should interact in practice. And so the fact that the court in Cowichan directed the Crown to engage in negotiation with Cowichan around what to do next is common. It's a common approach that the courts take. I think it's a productive approach because it really allows people to take their time and think things through. These are complex issues, and frankly, they're policy issues that courts don't necessarily want to really get into the weeds on, when in fact, the point of this work is not just about recognizing rights and Aboriginal and Indigenous rights and jurisdiction. It's about promoting relationships and reconciliation and trying to restore those relationships. So the next steps in this case will be negotiation between Cowichan tribes and the governments around what effects there might be, if any, on private fee simple. But I want to provide a factual clarification because Cowichan, the vast majority of the land that fell within Pluktunis was Crown land anyway. It was either public federal land or land that was owned by Richmond. Some of it was industrial, but a lot of it was unoccupied, undeveloped. And so Crown lands are not privately held in fee simple. So that's important when we're talking about some of the anxieties around this case. And the question of what happens if there are interactions with private fee simple lands is something that is between Cowichan tribes and the Crown. But they weren't seeking any remedies against private parties, private landowners. So the court didn't make any decisions on that. And that's consistent, I would say, with the general trend of Aboriginal title litigation, with a couple of exceptions we might talk about. But the courts are not inclined to make orders that are about third-party landowners without them being there, without them having the opportunity to advocate on their own behalf. And Cowichan wasn't seeking that in this case. So what's up next? Negotiation.
Well, I think people will be happy to hear that, but I kind of want to follow up a little. I was not at the Vancouver Real Estate Forum, but I know there was a session on this topic, and it was packed to the rafters. Everybody wanted to hear about it, and they had some lawyers and partners such as yourself. But what I heard was there was quite a bit of disagreement in terms of what does this actually mean? And I guess that surprised me. I thought, okay, for us in brokerage development, whatever, perhaps we're not sophisticated about this, but I thought lawyers would have a pretty similar aligned view on this, but I don't think that was the case. So have you heard that? And why would legal experts be disagreeing on the significance of this? Because I guess I heard some people saying, it's more of what you were saying. This sets the stage for negotiation. Some people had a much more sort of severe view of this is totally changing the paradigm of fee simple, land ownership, everything. So how is that the case that lawyers can arrive at such a different view of this?
The glib answer, Adam, is that lawyers love to disagree, particularly litigators. But I think in fairness, one of the challenges of this area of law is that it's really developing in real time, right? There's been a relatively small number of Aboriginal title trials that have been completed, and each case involves very different facts. Different remedies are being sought. There's different procedural choices. So on the one hand, you're seeing a relatively small number of cases that cause each case to take up a lot of space in the room, a lot of air, right? There are also court decisions in different jurisdictions. So commonly, when you have a new piece of legislation or a new legal issue across the country, you see different provinces, judges in different jurisdictions reasoning their way through the challenges and the problems raised by this new law in different ways. And so over time, there's more of a convergence that arrives, and the Supreme Court can provide guidance on this. But there is a component of this which is normal. The law is developing, so people have different views on it. That's part of the process of developing the law. I think also an important distinction here is really about what declarations are being sought. So this is why I mentioned a couple of times earlier that Cowichan was not seeking declarations in respect of third parties. It was really just focusing on a relatively narrow set of claimed lands. Some other cases might approach things differently, might raise different legal issues. It really depends on how the parties bring it forward. So sometimes the facts of the case matter more than the actual legal principles. And I think you're alluding to, among other things, Wollastigwe, the decision in the New Brunswick Court of Appeal, and where there was a decision that has also been largely interpreted and considered by a lot of legal experts and colleagues. And it's been a point of some confusion. How do we square the circle of the Port of New Brunswick saying one thing, the BC Superior Court saying another thing in Cowichan. There's a lot in there. These are lengthy decisions that you can mine for disagreement. But I think, and we can talk more about those specific cases, but it's more important, I think, to look at what is common between those cases. And that's ultimately that both Cowichan and Wolastoqey, and the cases that I'm aware of, have all made clear that whatever the process for reconciling conflicting rights looks like in the future, which is really an issue that is outstanding, but is being worked through in negotiation and possibly in litigation, there is a consensus that private fee simple owners are not negatively affected without having the opportunity to defend themselves in court. So both Cowichan and Wolastoqey were clear that Aboriginal title is focused on obtaining remedies from the Crown, not private owners. These kinds of pieces are part of what give me some confidence on the points of consensus. I'm not surprised that when it comes to implementing in practice, people say different things. But in fairness, the same is true of any property dispute, right? Outside of the Indigenous law context, there's lots of disagreement between lawyers, between parties about what it means to have different rights in a piece of land and whose rights should take priority and how they interact. And the courts deal with those kinds of issues all the time. And frankly, lawyers disagree on those issues all the time as well. So I don't think it's exceptional, except insofar as is the relatively new and quickly evolving area, each case really has significant impact on the way that lawyers think about and talk about what's coming next.
Okay, I appreciate that. And kind of a follow-up, I think that's good to hear. You mentioned like the precedent and how far that goes. Like, is what's happening here specific to BC, the legal situation in BC, the history of BC, or is this something, because of course the questions inevitably come, this is front page news, and then what this means XYZ in Ontario. Like, how specific is this to that province, that jurisdiction, that municipality? And you mentioned there are some other jurisdictions that are working through this similar dispute, that kind of in parallel. Is that right?
Mm-hmm. Absolutely. Yeah, I think in a formal sense, this is a decision of the trial court in British Columbia. It's not legally binding across Canada in the same way, say, a Supreme Court of Canada decision would be. But as we were discussing earlier, Aboriginal title cases that make their way to a final determination are rare. And so they're going to be studied. They're going to be reviewed. They're going to be cited in other cases. It's not every area of law where you can rely on the same 6-7 cases as the only reported cases on how certain legal principles should be applied, right? So they do have an outsized impact as resources, as ways to see how different judges, including trial judges, have grappled with the issues, and then where that takes us in terms of next steps. I think it's important to recognize as well that although the decision isn't binding or formally setting a precedent in other jurisdictions outside of BC, there is a larger national and global conversation about Indigenous land rights and colonization and the history of colonialism that it is contributing to, right? And that includes conversations around major projects. It includes conversations around development. It includes conversations around international law, like the United Nations Declaration on the Rights of Indigenous Peoples. And so this conversation has many participants and many data points, I think, that help to drive it forward. It's easy to see how these kinds of decisions will have knock-on effects given how much interest there is.
Yeah, and let me ask about this sort of bigger agendas we're seeing on the legislative side. So we all know about our conflict with the U.S., our new federal leadership. There's a big agenda around resource development, nation building, mega infrastructure projects. Like, this seems inevitable that this is going to interact with, it already has in BC and northern BC, and pipelines and gas terminals and all this. So do you see this like intersecting or like changing that? Like, it seems like the feds have become more aggressive about, we are doing this, and there's a lot less negotiation and veto at the lower levels. But how do you see the Cowichan interacting with those sort of bigger federal level mandates?
Well, I think one piece to clarify right at the beginning is that I agree completely that as we see an increased focus on Indigenous rights and jurisdiction, there will be more intersection with these issues of resource development and major projects. I think it's important to recognize that this is exciting. This is an opportunity. And we can talk more about why I have seen that in my work with clients, but it's actually an opportunity for better relationship building and more durable forms of economic reconciliation because rights are clear, governance capacity of Indigenous governments is increased. And so the opportunity to partner in these projects is greater than it has been in the past. So I think that's an important piece from my perspective is to clarify that misconception that, Indigenous governments are anti-development or something like that. And I can tell you from my experience working with lots of clients, that is not the case. Many Indigenous governments, they're pursuing economic growth in infrastructure and cooperation energy projects or resource development, land governance. The issue is not whether development can happen or should happen. It's whether it happens in a way that respects rights and jurisdiction, builds trust, and creates meaningful participation by the Indigenous parties. So that, I think, is important context when we're talking about that intersection. You and I were previously talking about some of the historical context of Indigenous economic development and barriers to Indigenous participation in major projects. And just to recap some of that for our listeners here, we have a history of Indigenous land dispossession, right? Lands and resources being taken from Indigenous communities without consent, without consultation, without compensation. And that's the opposite of building in a spirit of trust and partnership, right? We also see that historically, economic development opportunities for nations has been limited for all sorts of legal reasons that have nothing to do with them, which have created capacity gaps. So, for example, your listeners may not know that for many First Nations with reserves, it's extremely difficult to collateralize assets when reserved. And so historically, Indigenous access to capital has been very limited. But as industry and as lenders and as developers are starting to realize, the problem's not a lack of will or something. It's about building capacity and trust to do the work right. And I think that clarity around Indigenous rights and jurisdiction makes that easier. I'll give you one concrete practical example of this from my work. So one of the things that I do in my work outside of litigation is work around building Indigenous regulatory and legislative capacity. So that means that we have nations that are developing their own laws pursuant to their own inherent jurisdiction or land codes pursuant to federal legislation that enable them to have a more robust set of land use planning processes. So regulatory approval processes for projects. And where nations have done that, it is far less red tape, I think, than a lot of developers are used to seeing when they have to go to the feds and they have to go to the provincial government and they have to go to these different tribunal processes. It can be a bit of a one-stop shop to have an Indigenous-led regulatory process, a land use planning process that actually can help some of these projects move forward more efficiently. And when we talk a bit more about Aboriginal title, one of the components of it is not just rights in land, it's rights around land governance. So I see a lot of opportunity for increased partnership and economic development on these nation-building projects as Indigenous governance and jurisdiction grows stronger. So I actually think Aboriginal title is entirely consistent with economic development, and it's a vehicle for increasing Indigenous participation in these projects.
Let's talk a little bit more about the legal side. So when we talked about this earlier, you said there's three parties in play. There's the Indigenous nation, there's the Crown, who in theory owns everything, and then there's everybody else, owners, developers, people buying and selling land. So can you explain a little further and what role, if any, do property owners, developers, people who are doing leasing, planning, whatever in this area play, or are they just sort of adjacent to this whole discussion and it's between the nation and the Crown?
Yeah, I think it's an important point, Adam. And so First, I'll just restate and maybe clarify a point that I made earlier, which is that one of the through lines of these cases is that when it comes to historic wrongs or historic legal wrongs or historic breaches of the rights of Indigenous peoples, well before private landowners came into the mix, the Crown is responsible for remedying those breaches, right? And that's true not just of Aboriginal title, it's true of all sorts of other Indigenous rights litigation, whether it's treaty rights or Aboriginal rights. And in fact, the law of the Crown's obligations to Indigenous peoples is well established. It's growing, it's developing, but that's not new. And so when it comes to how courts in Aboriginal title cases understand whether it's compensation or remedies between the Crown and the Indigenous litigant, that's not new. So whether that's financial settlements or, remedies, there are other examples of cases where outside of title, these things get litigated. Say, for example, that there was a treaty promise to provide a certain amount of land that wasn't honored by the Crown. The resolution of that claim might be financial compensation plus an entitlement on the part of the successful nation to future vacant Crown lands to satisfy this outstanding, we call it a treaty land entitlement. But it's not a situation where you look at the land that they should have been promised, you see, okay, well, there's a municipality here and these private landowners here, and that land needs to be expropriated. The courts don't do that. The Crown isn't doing that. There's other ways to satisfy the Crown's failure to fulfill its obligations. So I don't see that part changing. I think it's important to focus on that aspect when it comes to remedy. But I think it's important to talk about private landowners, developers, people who have rights in fee simple. We talk to implementation of these rights. And title, your listeners will know that title is, at least in a legal sense, it's a bundle of rights. It's rights to do things, right? And so, we talked about use, we talked about occupation, we talked about selling or leasing the land. Those we call private lands, private rights in land. There's other rights that are public, such as rights to regulate the land, to tax the land, to legislate, and those vest in the Crown. So we have private rights and we have public rights. And Aboriginal title can affect both. But what we'll see, and I think Cowichan makes clear that there will be future opportunities to clarify how these private rights, the interests of fee simple holders of land that were granted perhaps unlawfully 200 years ago, but that they now have, how those interests are reconciled with the interests of an Aboriginal title holder. And that may require litigation. It may require other processes to address what that looks like. But the courts have said, really, the Crown needs to figure out what the solution is here. Even though the courts have said that, there's examples of Indigenous governments that are rights and title holders being proactive about seeking negotiated settlements, clarifying that they're not going to do anything to ever disempower or to expropriate or negatively affect the rights of fee simple holders. And we have an example of this in BC, not with Cowichan, but with the Council of the Haida Nation, where there's an agreement. It was the first ever consent finding Aboriginal title. And by consent, I mean the Crown's consented, the BC Crown consented, and the nation consented to this declaration because they had reached an agreement where, among other things, there was all sorts of measures in the agreement that were to recognize the transition of public rights over that land, governance rights, jurisdiction. But there was an agreement that the fee simple interests would remain under provincial jurisdiction. They wouldn't be affected or impaired in really any way. The only impact for fee simple in that case, and maybe this is a technical point, is in a case where someone dies without a will and without any heirs, in the ordinary course, that land reverts to the Crown. In this case, it would revert to the Haida Nation. That was it. So there were opportunities to, before even getting this declaration, clarify, okay, this is how Haida Nation, the Council of the Haida Nation, wanted to approach fee simple, putting everyone at ease. So I see value in recognizing that there's two conversations. Amongst these three parties, there's two conversations. There's a conversation with the Crown, and then there's a conversation, actually, perhaps it's better to say that there's three conversations, many conversations. A conversation between the Crown and the nation, a conversation between the Crown and private landowners around what they're not going to do, what that's going to look like. And then ideally, a direct conversation between the nation and those landowners to identify what will happen in future when it comes to reconciling the exercise of rights. So the three parties matter because those conversations all need to happen and are, to some extent, are happening at the same time. But I think it contributes to some of the confusion, recognizing, who is talking about what and with whom.
You're a litigator, maybe you even enjoy litigation, but you also said to me, this is the last resort. Like almost nobody wants to end up here. You mentioned how long this takes, years, and obviously there's a huge expense that goes along with that of the data collection and everything. So could this have been resolved without litigation? Like, was there a path to not get to this appeals court level, but to resolve this years ago or in an earlier way? And if so, like how could that have happened?
I think that the path to settling it out of court is becoming clearer, but you're right. It's always been an option. And I know for a lot of Indigenous governments and clients, litigation, as you said, it's expensive, it's slow. Yes, I might like it, but at the end of the day, there's risk and uncertainty. And so when you talk about the costs and benefits of litigation, a meaningful settlement is in many cases better. And that's why even the sort of issue by issue or piecemeal use of litigation to seek declarations on certain issues is something that courts encourage, right? It's that, okay, well, couldn't reach an agreement on this legal issue, let's give you some direction and then let you continue working it out. But until recently, courts were seen as really this high nation rising tide agreement. Courts were really seen as the only mechanism for officially confirming this, partially because these processes take so long. I work with a lot of clients doing modern treaty negotiations or self-government agreements. And these are negotiations between a nation and the federal crown and the provincial crown at times. And these things take decades, truly. There's self-government agreements that have been negotiated for 30 years without an outcome. And so in the large scheme of things, 30 years of negotiation is challenging. It's not necessarily effective. There may be policy reasons or political factors that drive that on the government's perspective. I don't have a crystal ball on that. But those pieces are part of what drive people towards litigation in these cases. The failure of negotiation, the failure of political will, or the lack of effective opportunities to negotiate. One piece that's important to recognize around the reason why I think we will see more negotiation, hopefully, than litigation, is this piece around complexity of the issues, right? And courts deal with complex issues all the time, don't get me wrong. And I don't just mean complexity in terms of the size of the issues. It also, can be the financial stakes. Courts deal with huge cases. But at the end of the day, some issues, including repairing the relationship between Indigenous peoples and the Crown, repairing the legal relationship between Indigenous legal orders and the Canadian law, these are things that, as the Supreme Court has said, don't happen in a single sacred moment. They happen over time and through relationship building. And so I think we'll see more negotiation of this now that, BC has signaled an appetite to have these agreements that clarify rights out of court. I also see these negotiations facing roadblocks or challenges. So there will still be litigation. I won't be out of a job. But from the perspective of our clients, almost, I would say actually in 100% of the cases, finding a constructive, forward-looking, negotiated settlement or resolution to territorial issues, land governance issues, is the preferred path.
Fair enough. Okay, so I'll put this to you. You'll probably say it depends or it's not clear yet, but just so we can clarify, I think many of us had not necessarily heard of Indigenous title before this case, hit the front of the Globe and Mail or whatever. So how would you describe Indigenous title? And that means fee simple. I think you hear people disagreeing a lot. They simply coexist. They're in parallel. This invalidates fee simple. It supersedes it. Do titles coexist? And if they do, how is that? I realize that's a pretty big question to chew on, but you're better equipped than me or anyone else to answer that.
Well, thank you for that. I will take a run at it and first just offer a clarification that it's just around terms, right? So Aboriginal title, I know Aboriginal is a word that we try not to use in the context of Indigenous rights and Indigenous peoples, but there's a legal reason that we do use it when we're talking about title, and that's because the Constitution says it. So when we're talking about Aboriginal title, it's a concept that has a history. It's a concept that's linked to particular constitutional law components. So breaking it down a little bit, I think in order to understand what it is, what the rights are, the rights associated with Aboriginal title, and then talking about the interaction with fee simple and other land interests is really the only way to tackle this. So first, let me start with what Aboriginal title is. The courts have told us Aboriginal title is a unique legal interest in land, sui generis, which is a fancy Latin word for a Latin expression for saying they're a unique class of title interests. It's not simply fee simple. It reflects common law and Indigenous perspectives on land, governance, responsibility, and relationships. So it's a kind of hybrid concept that the courts have created to respond to a challenging historical fact. The fact is not controversial. Indigenous people were here first, period. But there's legal complexity around how the developing nation of Canada in the early historical period of colonization developed its land tenure system that create challenges that we're trying to grapple with now. So it won't be surprising to your listeners that Indigenous people were living in the land that we now call Canada well before the arrival of settlers. They were using the land, there were complex economic relationships and governance institutions and laws before the assertion of Crown sovereignty. When the Imperial Crown asserted its territorial interests in Canada, it did so according to something you've probably heard of called the Doctrine of Discovery, which is an idea that we could talk about in more detail another time, Adam. But essentially, this doctrine is a common law way of saying, okay, the Imperial Crown discovered Canada, and that provided them with an underlying radical title to lands. This, and radical as in going to the root, a root title underlying all other forms of title. The Crown claimed this radical title and then began parceling out fee simple interest to settlers. That's the foundation for the modern land tenure system. But of course, this assertion of radical title ignored the fact that Indigenous people were living here before that point. They had their own rights, laws, and institutions before the Crown discovered it. So Aboriginal title is trying to reconcile these ideas, reconciling two conflicting facts. The fact of Crown sovereignty with the fact of the prior occupation and rights of Indigenous peoples. So the courts have found, the Supreme Court has said that the pre-existing legal rights of Indigenous peoples are a burden on this Crown underlying root title. So that's a bit about what Aboriginal title emerges to try and resolve, is this tension. So Cowichan is consistent with that. The Cowichan case is consistent with the idea that Aboriginal title is a prior right, it's a senior right, it's rooted in historic occupation, it doesn't flow from a Crown grant of land, and it's constitutionally protected. Again, this is the link to Aboriginal title, the Aboriginal rights protected by the Constitution. So that history is all well and good, but what are the rights of Aboriginal title? So the Supreme Court has said that Aboriginal title includes ownership rights similar to those associated with fee simple. So that's rights associated with land use, occupying and enjoying the land, possessing the land, benefiting economically from it, managing it. But because it's unique, it may also have other governance and public law dimensions that don't map neatly onto the fee simple concept. So this is an important piece to consider, right? That we have bundles of rights that on paper sound like they might not be able to coexist. Okay, well, if fee simple gives someone the right to use and occupy the land, and Aboriginal title says that this Indigenous community has the right to use and occupy the land, how do you align those things? How do you reconcile those things? That's a question that I think is raised by Cowichan that's interesting to a lot of listeners and commentators, including legal experts, is Cowichan says there's not a dispute that these two forms of interest, Aboriginal title and fee simple can coexist. They can coexist. We see overlapping rights all the time in real estate disputes and other forms of litigation. And the fact that there's overlapping rights doesn't mean that one side's rights disappear. This is something that gets sorted out through dispute resolution, mediation, negotiation, litigation. And I'll give you an example. So you can own a piece of land and retain those ownership rights in land while also leasing it out to someone who then acquires leasehold interest on that land, right? The leasehold interest in that land are no less real than the ownership rights. But while the leaseholder is exercising their rights to occupy, to use the land, the owner, their ability to exercise those rights is limited, right? They've contractually chosen to limit those rights. So it could be the case that, for example, in the context of, the Haida Nation example that I gave earlier, it might be the case that there's an underlying Aboriginal title that applies to ownership of the land and public rights in land, while existing fee simple owners still have all the same rights to occupancy and use that they would have otherwise had. It's only in the event of a conflict that those things need to be reconciled more specifically. So it's a bit of a hypothetical, and I offer that example of Haida Nation not because I have any specific insight into it, but because I think it is illustrative of the fact that the coexistence of rights can exist without those rights being diminished. Coexistence doesn't mean conflict will never arise, but those conflicts can be resolved fairly, and the courts are saying in a way that's procedurally fair, right? That's why the courts have, in various decisions, said, in a lofty way, we're not going to make certain orders around private landowners without them having the opportunity to participate, right? That's procedural fairness that is common to the courts generally. So reconciliation of these interests, of what it looks like to exercise Aboriginal title rights and what it looks like to exercise overlapping fee simple rights and interests, will have to be worked out, but it will have to be worked out in a way that respects both the public and the private interests, as well as that constitutional context. So I think it's just important to take away from that. When we're talking about Aboriginal title, we're not talking about the erasure of private land ownership rights or regimes. We're talking about affirming the existence of overlapping and coexistent rights in a way that requires reconciliation. And the courts are saying, who should be leading that reconciliation work? The government, not private landowners, so as to provide for a resolution that respects all of the interests in that land.
Okay, so a simplistic question from the non-lawyers here. What is the impact of treaties? This is something I can go to the Ontario government website and open it and say, there's a map and here's all the treaties. And Peterborough is in Treaty 20 and Sarnia is in Treaty 29 and everything's covered by a treaty. My really simplistic understanding is that that's not the case in BC. You don't necessarily have everything covered by a treaty. So how much is that unceded land factor affecting the legal questions here? Or is that just like not relevant to what we're talking about?
Yeah, I think it's a good point. And certainly BC has a distinct history compared to other provinces where there are, for example, numbered treaties. And the result is that since treaties weren't made with Indigenous governments in British Columbia, the land is unceded. That was the work that the Crown was trying to do with treaties, was to offer benefits in exchange for the surrender of land interests, right? I do treaty litigation, so I could talk to you about this for a long time, but I think it's important to recognize that, yes, in BC, the fact that we're talking about unceded lands may explain some of why Aboriginal title litigation has been commenced earlier or been more prominent. But the existence of a treaty doesn't end the legal analysis when it comes to territorial rights or Aboriginal rights and title rights, because, treaties are the treaties in one sense. We have a document, but we have promises in treaties that are subject to all sorts of legal and historical questions about what the actual deal was and whether the Crown delivered on it, right? there's very significant cases where there was not a meeting of the minds, as we say, around what was promised by the Crown, presence of coercion and other power imbalances in treaty negotiation that have led to extensive litigation around the effects of treaties from the interpretation perspective, from an implementation perspective, from the perspective of the honor of the Crown generally. Was the treaty conducted in an honorable way? So it's important to recognize that these issues have dominated more of the litigation in Ontario. But Aboriginal title is not just one thing. It's a bundle of rights, right? A bundle of rights over a specific area based on a historic fact of exclusive use and occupation. And the fact remains that in Ontario, just as in BC, Indigenous people were here first. The fact is unchanged. The effect of a treaty on how those interests are litigated or asserted or exercised will make it look potentially different than in BC. But the door is not closed to advancing these territorial claims just because there was a treaty. There's all sorts of issues with treaties, and more importantly, there's all sorts of developments in the way that we understand what those rights and interests that make up Aboriginal title look like and how they can coexist with treaty rights, Aboriginal rights, and the fee simple rights of private landowners.
Okay, thank you. I think we're down to the last maybe two questions, but these are kind of big ones. Will we eventually see this go all the way to the Supreme Court? Is that where this needs to end? Or it seems like you're saying there's a lot of off-ramps where we could kind of negotiate our way out of this, and it's not just going to be the next years and years and years of escalating this to higher levels of courts. So again, like I think there's some fear about where this is going, or it's going to have this huge impact. But is it going all the way to the top, or is there a way out here for everybody?
I mean, if I had a crystal ball, but no, I think it's a fair question because, particularly given how much time and energy was spent on the trial, everyone has an interest in finality and certainty and an understanding that the state of the law is resolved. But there's also an interest in ensuring that it's done right. And so appeals happen for all kinds of reasons, right? It's, there's political reasons, but there's also reasons around the development of the law. So any big case, there's always the potential for an appeal. I think one of the pieces that has become increasingly relevant when we talk about the role of appellate courts, such as the Supreme Court, in cases like this, is that there is some judicial restraint around what types of declarations are being made or what types of findings are being made so that there's opportunities to negotiate. And I expect that if this does find its way to the Supreme Court, there may be specific issues, it may be on some subset of issues, but there's also likely to be some direction from courts to try and resolve some of the many potential issues out of court. I think a factor that does tend to favor the need for Supreme Court clarification. And, you don't have an automatic right to get to the Supreme Court. The Supreme Court needs to grant leave in civil cases such as this. And one of the considerations is whether the question is of national public importance. And so you and I might agree or disagree on what that means, but one of the factors that has been considered by the court when we're talking about whether a case or a legal question is of national public importance is where there's disagreement between different provincial appellate courts and the law is in need of clarification. And so I think that if we see more and more divergent approaches in different trial decisions or appeal cases, that factor does tend to favor the Supreme Court granting leave. But, as I said, I don't have a crystal ball. So I wouldn't be surprised if there's appellate clarification. It would take a while to get there. But I do think it's important to recognize that litigation is not the only way through this. And the courts have told us this for decades now. So I don't see that changing. I think that the courts will still want to see as many of these issues as possible dealt with out of court.
Okay. And as the final thing, it's not even a question. Let me give you the soapbox. There's obviously a lot of fear, doubt, confusion in this area. talking to people in the real estate industry, which isn't your normal constituency or people you work with, like, what is your main message to us, to landlords, to brokers, to developers about like what's happening and how we should interpret it?
Do you have time for two quick ones?
Sure. Two's great.
So first, I would say private landowners' interests are not going anywhere. The courts are telling us that the Crown is responsible for reconciling Aboriginal title with fee simple interests and addressing those historic breaches. So the legal focus is on the Crown and the Crown's responsibility, not liability or uncertainty for private parties. The second point is Aboriginal title and Indigenous jurisdiction is a source of opportunity for economic development and reconciliation, for developers, for lenders, for municipalities, for the real estate sector. There really is a path forward for earlier engagement and better relationship building, respect for Indigenous governance, and partnership that can help to work with nations that are title holders, that are advancing their territorial claims, their jurisdictional and legal aspirations to produce great projects, more sustainable and successful projects, the types of projects that are needed. And so I want to leave listeners with the message that building Indigenous governance capacity, whether it's through Indigenous nations going to the courts or through negotiated settlement or through business partnerships, creates more opportunity for mutual benefit with the private sector.
I think that's a great point to end on, and not one that maybe is emphasized enough. This is seen as only a negative or a downside, and nobody ever talks about the opportunity here. So thank you so much. I think we're going to wrap up the show. Thank you, Adam Wheeler, partner at Fogler Rubinoff. I don't think we've ever had a lawyer on this show before. We've certainly never addressed this topic. It's a complicated one. It's not one I know a lot about. So I really appreciate you joining us. And thank you to all of our listeners on Colliers Talks. We really appreciate you joining us, and hopefully this is helpful to you in informing you and going about your daily work in the real estate business. So thank you, Adam, for being here, and we look forward to seeing you again soon.
Thanks, Adam.
Thanks for listening to Colliers Talks podcast. To learn more about Colliers Canada, our experts, and our solutions, visit collierscanada.com or find us on LinkedIn, Twitter, and Facebook.